It's Friday afternoon. We've locked the door because all the pizza goes in my tum-tum and you can't have any. And also because it's time for another edition of our weekly podcast, Tales from the Brown Desk. I'm Jake Rigney of Rigney Law LLC. With me as usual is my law partner, wife, and the foxiest member of my household, Kassi Rigney. The poor soul tasked with writing our motions and laughing convincingly at my jokes is Terry Alm. Friendly reminder, Tales from the Brown Desk is a free-flowing conversation involving two foul-mouthed attorneys. It may include graphic descriptions of sexual activity, violence, and other things people do with no pants on. It may not be suitable for children, Melania Trump, Scott Baio, Newt Gingrich, or Tucker Carlson. Listener discretion is advised. Here's Terry.
Hello, everyone. Hi, Jake. How are you today?
I am okay, Terry. How are you?
Pretty good. That was probably the shortest answer to that question ever.
Well, lawyers tend to give long answers. That's sort of our jam. People think we get paid by the word. Some of us maybe do. I don't, well, at least not for this podcast, but...
Hi, Kassi. How are you?
Hi, Terry. I'm fine, thank you.
Good. So last week we talked about marijuana metabolites and the law surrounding it.
Yeah.
And this week we're going to talk about some recent Court of Appeals opinions.
Okay. Case law update.
Yes. But before we begin, I have a question.
Oh, okay. The answer is yes, you can have Monday off.
Great. Perfect. Well, that wasn't my question, but I'll
okay.
take Monday off.
Okay.
So anyway, I'm sure you two have heard of this movement, defunding the police.
Yeah.
It is a movement that's going on right now all across the country, and Forbes reports that at least as of August, 13 cities across the country have done so, at least in part.
Mm-hmm.
Some of the cities have cut public police department funds, and they're reinvesting some of that money into social programs, including food access, violent prevention, and abortion access. What is your stance on this movement?
Well, here's the thing. It's a very complicated issue, and so you're going to have a hard time, especially from a lawyer, getting like a simple, I agree with it or I disagree with it kind of thing. But it's the word defund means to cut off all funding. And most of the time, most of the people who are using that word don't actually mean that. What they mean is we ought to cut funding from the police or divert funding from the police to other social services so that the police don't have to deal with all of these things that they're not very well equipped to deal with. Rolling in their squad car with their gun and their bachelor's degree in criminal justice. So my short answer, this is the short answer, is that I think it is a very good idea to take some of these things off of the police's plate, right? The police officer is not a mental health professional. It should not be his job to go track down every autistic person or mentally ill person who's walking through the street and figure out what to do with them. Because police officers usually, they do one of two things. They either let you go and nothing happens, or they put you in handcuffs and take you to jail. Like those are the two most likely outcomes from a police encounter. And that is not always what society needs. So I think it's great to have other options for people in those types of situations. Take that burden off of the police so that they can spend more time chasing down who they really want to be getting after anyway, right? The bad guys, the mythical bad guys who are out there causing so many societal ills. So in that sense, I like it. To the certain extent, there are some people who are saying like that we ought to just not have police anymore. No, I don't think that's a good idea there. And you'll get this even from criminal defense attorneys. There are bad people in the world who will do bad things to you, and not having police around to either come catch them or stop them is not good for society either. So that's the short version.
Kassi, any comments?
Other than I just generally agree. I mean, the police do provide an important service, and I do think that they've burdened with a lot of things that they shouldn't be, and appropriate funding of other resources can sort that out, I think.
Right, and that burden is real. It exists. It does not excuse certain police officers whose behavior has been egregious, right? The guy up in Minnesota, I forget his name now, Golfin or something like that, whatever. That guy is probably going to prison, and that guy probably should go to prison. The burden that other officers carry does not excuse him from what he did.
Now, on to our topic of the day. Some recent Indiana Court of Appeals opinions. The first Court of Appeals opinion that we will talk about today is Chandler versus the state of Indiana. In this case, Chandler appealed the trial court's imposition of fees and costs after a jury had found him guilty of theft. A little background on this case. In July of 2019, Chandler stole a donation box from inside a Indianapolis VA hospital.
Oh, no.
Yeah.
That's almost Florida man material.
It is. The state charged him with theft, a Class A misdemeanor, and a jury found him guilty.
Mm-hmm.
At his initial hearing, the court found Chandler indigent and appointed a public defender. They also found that he could pay part of the fees to represent him, so they asserted a $50 public defender fee.
Right.
At sentencing, the court sentenced Chandler to 365 days, with all but time served suspended to probation. The court also asserted fees and costs against Chandler in the total of $355. Included in that sum is the original public defender fee and a $4 fee to an unknown arresting agency, which I believe is the VA hospital's internal police. The court did not suspend Chandler's obligation to pay the $335 and did not hold a hearing to determine his ability to pay, and so an appeal ensued. He raised two issues on the appeal: whether the trial court erred when it imposed fees and costs without holding a hearing, and whether the court erred when it imposed a fee that was not authorized by statute, and that fee was that $4 fee. The state conceded on appeal that the trial court erred in both respects, and the Court of Appeals agreed. They reversed and remanded with instructions. What are your thoughts on this case?
I mean, it's pretty cut and dry. I don't know. What are your questions about this case? I mean, you read it. It seemed the court got it wrong. Everybody agreed.
Okay, so my question.
This is the classic Kassi turn it back on you routine. What questions do you have about it? You just explained it all.
You seem to understand everything about the case, Terry.
Here's my question. Okay, so the appeal ensued on $335 fee.
Yes.
That the defendant was required to pay.
Yep.
And I wonder, my mind goes to, how much did the taxpayers pay the public defender to prepare the appeal brief?
Right.
How much did the taxpayers pay the state of Indiana when they replied to that brief?
Mm-hmm.
How much did the taxpayers pay the public defender when he replied to their response?
He may not have filed a reply.
He may not have. How much did the taxpayers pay 3 judges in the Court of Appeals to sit down and read all these briefs and then to write an opinion?
Yeah.
This doesn't seem right in my eyes for taxpayers. For his $335, us taxpayers could have paid that and then, I don't know, maybe remove this judge from her... from her seat, since she's making all these rulings that don't go with the law. Like, how much do we have to pay for justice?
I'm going to tell you something that you've probably heard before, Terry, but I'm going to say it in a Southern accent so it sounds familiar, okay? Are you ready?
Yes.
Freedom isn't free.
No, it's not.
It's not. Look, $335 is not an enormous amount of money, but it's not nothing either, right? And the bottom line is the Constitution guarantees this guy, I forget his name already, but they guarantee this guy procedural due process. And we have laws written about how this is supposed to be handled. And when the judge doesn't do it, What's he supposed to do? Is he supposed to just take it? Is he just supposed to say, well, they broke the law, but okay, I'm going to pay it anyway? Or is he supposed to appeal? He's supposed to appeal, right? But yeah, it cost the state of Indiana way more money to litigate this issue than they would have made if he had paid the money.
Couple of comments. One, in defense of this judge, they call it practicing law for a reason. If it was, as easy as 2 + 2 = 4, we'd be paid differently, I assume. So in their defense. Now, the other thing that this case is value, or the ruling in this case's value, is beyond the $300, because what these case law do, that you can't go to the court with a hypothetical and get rulings. It has to be a legitimate claim in front of the court. So while this case was only $334, all lawyers in Indiana and all courts across, now this is a very clearly written opinion. It was laid out very well, and now that is a resource for all lawyers and judges going forward to use in their cases, so hopefully this error is not made again. And so while this case was only $335, how many other mistakes is it preventing?
Right, and not only that, but this is going to blow your mind even more. The most important part of that entire opinion isn't $332 or $4 or $5, whatever. It's the $4. The $4. The court ordered him to pay $4 to the VA for their investigative costs. That is not an authorized fee that you can impose on someone. But imagine if it were, right? Now the police can start charging you money for how long their investigation takes. Then the next one's not going to be $4, is it?
No.
The next one's going to be hundreds or thousands, and it's going to turn into a new forfeiture, right? Just like the problem we have with forfeitures now in the United States, where the police use it to, buy themselves the fanciest stuff, and they take money that they don't really have evidence is related to crimes and just wait and see if they can prove it. They'll do the same thing with investigative costs. And so this opinion is very important for that, because it says to the police, do not come to the court and ask them to make the defendant pay your costs of investigation. That's a government function. We pay taxes for it. Do your job. Don't come back and try to take it from the defendants. I've had that argument with police officers before, back when I was a prosecutor, and I told them they weren't allowed to do it then. But that will not stop the next young enterprising law enforcement officer who wants to pad his budget a little bit from trying to lay these fees onto defendants. And for that reason alone, this opinion is important. And it's good that we spent thousands of dollars in judges and attorneys' salaries so that we have that in black and white, and we can point to it the next time some police agency wants to try to hang their bill around the defendant's neck.
That's a very good point. So now we're going on to our next Court of Appeals opinion. And this is Gogarty versus the state of Indiana. How do you say that?
Is it Gogarty?
Gogarty.
Goharty. Gogarty.
You guys can't even agree on how to spell the name, and it's in black and white. I'm pretty sure it's Gogarty. I don't think there's an H in it, Kassi. I think
okay. Well, at least I'm reading what I wrote, which I wrote it incorrectly, which was Goharty is what I wrote.
Right, because even you can't read your handwriting.
So, Gogarty, right? Gogarty.
Gogarty. Gogarty. Sorry, go ahead.
Can I call him Go for short?
You can call him Chad if you want.
We're switching Gogarty to Chad for the sake of me getting through what I got to say here. So, in July of 2019, Chad, he was taken into custody and charged with a level 6 felony for failing to register as a sex or violent offender.
Okay.
A preliminary hearing was held in February of this year. During the brief hearing, Chad's counsel told the magistrate judge, I had offered to waive jury trial, and so we are here today to do it formally. The state offered no objection, and the magistrate simply pronounced in open court that the parties waive jury. Chad was present at this hearing, but he did not speak. The magistrate therefore ordered that the jury trial was now a bench trial. The bench trial was held, and the trial court found Chad guilty as charged and sentenced him to 547 days with 427 days suspended to probation, minus credit for time served. This appeal ensued. On appeal, Chad asserted that he did not personally waive his right to a trial by jury, and therefore the waiver was invalid. The state conceded that reversible error occurred, and the Court of Appeals vacated Chad's conviction, reversed and remanded it for a new trial. What are your thoughts on this case? Like, Chad was there sitting, like, did he personally have to say it? His attorney can't speak on his behalf?
Well, with your right to trial by jury, that is one of the things where the defendant has to be more involved. It's just so sacred of a right that the court has to make sure that representation is coming from the defendant and not his attorney. And that it's full and knowing and really from him. It's just one of those things. Most of the time, you're right. An attorney can speak on behalf and act on behalf of the client without having to double check. But this is one of those topics that they take a more careful stance with.
Yeah, there are just certain things that the lawyer cannot do for the client. One of those things is plead guilty, for example. You cannot have a guilty plea in the United States of America without the defendant speaking up and making it clear that he is waiving his rights. Not the attorney is waiving them for him, but that he understands what he's doing and that he's waiving his rights. And it's the same with waiving your right to a jury trial. So in that case, he had decided apparently, or his lawyer decided for him, that he was going to have a bench trial, and the judge was going to decide whether he was guilty or not guilty. But the judge, and case law has been pretty clear on this for a while, so I guess what I'd say is that this judge kind of had a boneheaded move there, because I think almost all judges know, and he or she probably knows too and just didn't think about it, but you always have to inquire of the defendant themselves specifically to make certain that they understand what a jury trial is and that they're waiving it, and that instead a judge will be deciding whether they're guilty or not guilty. It's not a long hearing to do, but you have to do it on every case where the defendant waives jury.
So this kind of takes me to waiving an initial hearing, where instead of going to the initial hearing and the judge telling you what your charges are and the maximum and minimum penalties, then an attorney can do that on certain offenses. I guess I was surprised to learn that Chad won his case here, because I pictured him in court and he had the opportunity to speak, but he didn't speak. And I think maybe his counsel would have advised him, like, with an initial hearing of what it means to waive this.
It is also the responsibility of the court and the state to protect these core constitutional rights of the defendant. And the fact that he didn't speak up, he's represented by counsel. None of the lawyers that were there handled this properly. Not his counsel, not presumably the judge was a lawyer. And it's just your right to trial by jury is just so sacred. That they treat it that way. And that's different, think about in their waiver to initial hearing. An initial hearing is an information only hearing. So what you're waiving is a statutory requirement that you be on the record for that advisement. So, you're not giving up any of your rights in that. You're passing on the requirement that be done on the record. So there's significantly different waivers. It says waiver, but one's really, really important and one is less important.
Yeah, there's no constitutional right to an initial hearing, right? You don't have the right to go in front of the judge and be informed of in person, be informed of what the charges are against you and things like that. You have the right to know what the charges are against you, and they can do that by providing you a copy of the charging information. But you do have a constitutional right to a jury trial. And Kassi's right. It isn't just the judge who sort of had a boneheaded move there. It's all three of them. He didn't say anything. You're right that Chad didn't say anything, but he's not the legal professional in the room.
Right.
There's three legal professionals in the room at least, and probably some court staff too, and they all should have known that he had to be questioned specifically about giving up his rights in that fashion, and he didn't do it. None of them did that, and so that's why the Court of Appeals overturned it. And the Court of Appeals had this issue before, and they've already told the courts, you have to do that on the record. You have to inquire of the defendant. So this time around with Chad, the Court of Appeals didn't really even have an option because there's precedent. There's already, appeals court precedent saying that they have to do it, and they didn't do it. So they didn't really have any choice but to overturn his conviction.
So now he gets a jury trial, and I'm sure he's hoping for a different outcome.
Well, I don't know if he is or he isn't. I mean, he got probation, right, on a level 6 felony. Well, it doesn't matter. I don't know if he is or he isn't looking forward to having another trial. The bottom line is that sometimes these things get overturned and reset for trial, and then they plead again, or something else happens, so who knows? He probably won't go to trial again, right? Because he already knows how that's going to go. Although sometimes evidence disappears too, and it's possible the state doesn't have all the evidence that they had when they tried it the first time. So who knows? But just because it got overturned on appeal doesn't mean that he won't end up pleading guilty to it or going to, so it's hard to say.
Interesting. Now we have one more case to talk about, and that is Brown versus the state of Indiana. In this case, following a bench trial, Brown appealed a conviction of a Class A misdemeanor resisting law enforcement, claiming that the state presented insufficient evidence to convict him. Brown's issue on appeal was, did the state present sufficient evidence that the officer was lawfully engaged in the execution of his duties when he entered Brown's home and arrested him?
Right. Keyword being lawful.
And a little background here on Brown's case. In March of 2019, the Indianapolis Metropolitan Police Department was dispatched to a home later determined to be Brown's residence. The officers made contact with Brown at the front door. Brown was inside of his home with the door open but behind a screen door, and the officers were on the porch. The officers asked Brown numerous times to step out on the porch to speak with them, so he would be out of the presence of the children that were inside. They didn't want to make an arrest of him in front of his kids. Brown refused to do so, stating that they can converse just fine from where they were. Eventually, Brown turned and he said he asked one of his children to get him a shirt and shoes because he wasn't dressed properly to go outside. And when he did that, the officers came in stack and tackled him. He ended up being arrested and then charged with a handful of things. Let me see. The state charged Brown with 6 counts. Counts 1, 2, and 3 alleged strangulation, domestic battery, and battery resulting in bodily injury for acts that he committed against his wife. Counts 4 and 5 alleged battery and domestic battery for acts committed against another individual in the household. And then count 6 alleged that Brown committed a Class A misdemeanor resisting law enforcement. On October 7th of 2019, the state dismissed all charges except the resisting law enforcement after their witness failed to appear for a taped statement. Now, Brown waived his right to a trial by jury, and the court held a bench trial in January of this year. The officers testified to their facts that they greeted him and asked him to come out, and he was very belligerent with them and would not cooperate. Brown denied those allegations, and eventually the cops came in and arrested him. The trial court, after taking the matter under advisement, found Brown guilty and sentenced him to 1 year, all suspended and no probation, and Brown now appeals. He asserted that the state presented insufficient evidence to convict him, and the Court of Appeals agreed and reverse the judgment. What do you think about this case?
Well, it was the right ruling. It highlights how complicated it is for police when serving warrants and when they need one and where they can go and what level of offense and all that. And I dealt with that when I was a prosecutor working with police. And I mean, from their perspective, they had probable cause to arrest him. And I mean, it laid out there wasn't an exigency, but it's very nuanced area of the law, and it's complicated. It's tough for officers to keep it all straight, and especially in the heat of the moment. I think it's a good opinion. As far as bringing us back to the other conversations we had, notice the sentence, and he appealed it. Well, think about here, like, arguably that could be wasted taxpayers' time because they undo it, and so what? I mean, he walked out, he had the conviction, but he didn't have probation, he didn't get any jail time, any of that. But think about how this opinion can be used in the future to keep police officers and prosecutors, in check in their behavior in these kind of situations. Because I thought it was a good, well-written opinion and clearly laid out the law.
The thing I took from this, and I'm going to try to phrase this as delicately as I can. You've heard me on the podcast many times before talk about how important it is to have a good defense lawyer fighting for you, right? Because you don't know what you don't know, and you need somebody who's got experience and understands all these things, right? Well, the flip side of that is also true, which is that it's very important that you have good prosecutors working on your criminal cases in the county where you live, right? If you have to choose between somebody who's got a lot of experience and somebody who's got little to no experience, you usually want the person with experience working on that case, right? The Court of Appeals overturned this conviction because they said, yes, the police had probable cause, but no, they didn't have exigent circumstances.
What is exigent circumstances?
Some important reason why they couldn't go get a warrant instead of just busting in and arresting him, right? Now, did those exigent circumstances exist in a domestic run with kids in the home and the husband getting arrested and the wife being outside? Yes, they probably did. I mean, I can't say for sure because I wasn't on the case. Those exigent circumstances probably existed that probably would have justified what the police did in this case, but it was not in the record. There was no testimony about it during the trial. And that's the prosecutor's job. That's on them to present that evidence when it exists. Now, if it didn't exist and I'm guessing incorrectly, then I apologize. I don't know who the prosecutor is on this case, but my guess is if you talk to those police officers, they'll tell you that there was exigent circumstances and that they can enunciate those things if you ask them about it. But if you don't, and you just assume they're the police, so what they do is lawful, then this is the kind of opinion you get sometimes. It's unfortunate, but this is what happens when you don't fund the prosecutor's office and they have a constant churn of new people, right? The prosecutor that worked on this case is probably less than a year from law school, right? Probably doesn't have a lot of experience. They're trying a misdemeanor bench trial. And when you don't pay the prosecutors enough money, they leave. And that causes a lot of churn, especially in the low levels, because there's a few high-level positions and then a lot of medium and low-level positions. But the more people high up in the chain leave, the more they have to push these young people up before they're ready. And next thing you know, you have no one in the bottom levels who have any experience at all except their supervisors. And there's 15 or 20 baby prosecutors for one supervisor. And these sorts of things happen in those low-level courts when you don't produce the kind of environment for prosecutors where they want to stay, where they want to stay and keep working there. And this, they don't get burned out by the stress. And trust me, that's coming from a former prosecutor. So I know a little bit about what I'm talking about.
What are the elements for the offense of resisting law enforcement?
It's a long statute. I don't know if I can remember them off the top of my head. You have to prove that the defendant knowingly, or because there's two different kinds of resist too. There's resist by force and there's resist by flight. So this isn't a flight. I don't think it was charged as a flight. It was charged as a force. And it's the defendant knowingly or intentionally forcibly obstructs, resists, or something else. I don't remember that part. Interferes, that's right. Forcibly obstructs, resists, or interferes with a police officer in the execution of their lawful duties as a law enforcement officer. That's not quite it, but it's something like that. And so fighting while they're trying to arrest you, either by tensing up or putting your hands under your body while you're down on the ground, that counts as resisting. The sole issue on this appeal was that the police officers were not acting lawfully because they have to have exigent circumstances to go with probable cause if they're going to arrest you in your own house.
Now we're going to cut to a short commercial break, and when we come back, we will bring you the latest Florida Man news.
Today's update on Florida Man is brought to you by hydroxychloroquine. Hydroxychloroquine, remember me? That lupus medicine that the president said would totally work on coronavirus.
Spoiler alert, it didn't work. On the other hand, though, it's probably not worse than meth, right?
Do we have science to back that up yet? I mean, I know there aren't a bunch of lupus patients running around scratching their faces off, so we've got some solid anecdotal evidence, but I'm going to need a couple of months-long double-blind experiments where some people get meth, some people get hydroxychloroquine, and some get a placebo. And I also need video of the whole thing because that sounds awesome. This message not actually brought to you by hydroxychloroquine.
So God doesn't talk to me, and I'm really glad about that because apparently he's ordering Florida Man to break into his neighbor's home. Newsweek reports that authorities...
Newsweek? Florida Man made Newsweek.
Yes, he did. Well, they report that authorities arrested Florida Man after...
Wait a minute. I'm sorry to interrupt. Did he make Newsweek or did he make Newsweek.com?
That's a good question.
Because they're not the same. They're not the same at all.
Are you asserting that Newsweek.com is not owned by Newsweek?
No, I think it is, but I don't think any of the same people write for them.
Oh, okay. Well, anyway, Newsweek, probably.com, reports that authorities arrested Florida Man after he claimed that God ordered him to break into his neighbor's home, and he threw a Bible at the officers when they arrived on scene. Florida Man's neighbor reported that Florida Man asked if he could borrow some clothing, but the neighbor declined, and shortly after that, he left his house. Upon returning, approximately an hour later, he found his front door kicked in. Mm-hmm. While he was checking out the damage, Florida Man came over wearing only his underwear. And he said, "I fucked up, man. I was mad." When deputies arrived at the scene, Florida Man shouted as he approached them. He raised his hands from behind his back, revealing a Bible, and said, "I condemn you." And he threw the Bible at the deputy.
Mm-hmm. Yeah, this all makes sense because, as we know, Jesus said that with regard to your neighbor, you should definitely kick. You should love your neighbor, but you should also kick in his door and steal some of his clothes. And this also lines up perfectly because Jesus said when they slap you in the face, you should definitely throw your Bible at them. works perfectly.
So, like, if you go to the trouble of kicking in the door, and like, what I thought you were going to say, which would have been better, is if you said, well, he was inspecting the damage. The Florida Man walks up in some of the neighbor's clothes, but he was just in his underwear. Like, you go through the process of kicking in the door, but then you don't take the next step of like going to get the clothes.
Right. Yeah. So Florida Man threw his Bible at a deputy with force and momentum. Striking.
That is some cop talk right there. He put that in the report because he wanted to make it sound worse than it was. Like you can't throw something without momentum.
Yes, and those are quotes from the report. Force and momentum.
Throwing a thing requires force and momentum, physics major.
and striking the left side of the officer's face and jaw. Ooh. Records show that deputies fired a taser at Florida man to subdue him and handcuff him.
The deputies didn't turn the other cheek either.
No, but as Florida man continued to approach after being tased in an aggressive manner and ignored all commands, another deputy had turned to the other cheek and pulled his taser and tased him. Deputies placed Florida man under arrest and transported him to jail. He was charged with burglary, petty theft, battery on an officer, resisting arrest, and property damage. And the deputies asked Florida man why he entered the neighbor's house, and Florida man told him because God told him to.
Did we get any more details about exactly how this discussion went? Was it like, hey, I really need some clothes, and my neighbor won't give them any. Go break into his house. Ha ha ha.
I think Florida man just mistakes all the voices. They just call them all God. They're not, they just misidentify all of them as
mental health issues. Yeah, that tracks.
Yeah. Now, CBS 47 reports Florida man is in jail after a fight with his cousin over which was better, whole milk or almond milk.
Whole milk is clearly better.
Obviously. And I'm a vegetarian.
Well, I would say almond milk, but so it might get a little...
Well, let's fight.
Let's fight. No, this merits a fight with a knife, mind you. Because
what? I withdraw from this fight.
Was one of them trying to force the other one to eat, to exclusively consume the lesser product for the rest of their lives? I mean, it just seems like, why don't they just drink their preferred drink and move on with their lives?
Right. But I guess Florida man, and it didn't say which one was for, like, I don't know if the guy with the knife was for the almond milk or the whole milk. But so a criminal complaint states that a deputy responded shortly after 2 p.m. Sunday to a home where Florida man and his cousin were arguing over which was better, the whole milk or the almond milk.
So Florida man and his cousin, they're not just both Florida men?
Well,
like it's Florida man and his cousin.
Florida man is the one that gets arrested.
Right. The one who gets arrested is Florida man.
The one breaking the laws is Florida man.
Did
Florida man's cousin was
this just this week or was it a while ago?
Sunday.
Like, so 6 days ago?
6 days ago.
Well, football was on. Football was on, and they're busy fighting over milk. By the way, I'm pretty sure the whole milk guy is the one who had the knife, if you think about it.
Oh, yeah, that's what I would assume.
Almond milk guy would not threaten to stab somebody because he's obviously vegetarian. Oh, well, he might just be lactose intolerant. I don't know.
Yeah.
Yeah, that's a toss-up.
Well, their verbal argument became physical when Florida man became enraged at his cousin for disagreeing with him.
That tears it.
Well, I'll admit, I'll agree with Florida man here that any milk is better than almond milk, nut juice. Sorry, it's not milk.
But that's cow titty juice compared to nut juice. I don't know.
Well, it's called milk. We call it milk when
Are we
women
still doing
produce
phrasing?
Well, listen, we always like to laugh at well, should we talk about Justin's nut butter?
We shouldn't, because that's not actually what it's called. You just like saying Justin's nut butter. It's called like Justin's peanut butter.
But he has almond butter, and I know he at least has almond butter as well. So I just called it as an umbrella term for the Justin's nut products.
And we have come to a grinding halt because we cannot get over talking about nut milk,
almond products,
nut butter.
My point ultimately was that I agree with Florida man that whole milk is better, but this is just an example where you just kind of leave these things alone. I mean, this is a true topic where you can say, well, we just agree to disagree. We can still be friends and like different milk.
Right. Leave Brittany alone.
Yeah.
You don't have to stab Cletus over his love of almond milk. It's not that deep, man. It is not that deep.
Isn't his time consuming almond milk in the future punishment enough?
Now, Florida man proceeded to punch his cousin with a closed fist to the left side of his forehead.
Okay.
The cousin tried to punch back but missed.
Of course, because he's an almond milk drinker.
Then he became scared and ran.
Of course, because he's an almond milk drinker.
Florida man pulled out his pocket knife and chased him.
What? See, that's just too much. It's too much, man.
Yeah, Florida man.
You made your point.
Florida man, no, he wasn't done. Florida man caught up with his victim, with his cousin, and struck him with a knife, causing a small cut to the man's torso. The uncle intervened at this point, grabbing Florida man and separating the two.
So we just got to stop on that fact for a second, because I just want to back up and recap here. Two Florida men get into an argument about which kind of milk is better. One punches the other in the face over it. The other one tries to punch in response, misses, runs. First guy, puncher, then pulls out knife, and uncle is just watching. He's just like, I don't see any reason to get involved in this at this point.
Not yet.
Only after the stabbing is the uncle like, well, I guess we better go break them two up.
Well, I find it interesting that I'm not wishing that the cousin or Florida man got stabbed, but that he pulled a knife and then hit him with it instead of you. I mean, I guess I was thinking if you pull a weapon on somebody, you should plan to use it. But I mean, I guess it's I have a gun at home, and if I got caught in the house with it, I'd probably just throw it at the person and run away. So I guess I understand that, but I've never out of anger gone to a weapon, and then I mean it's for stabbing, and then he hit him with it.
Why hit him, Chad, when it's made for stabbing? I mean, it's the whole point is to cut meat off of human bodies. Come on.
Well, and I guess, you know, didn't he prove his point when the guy ran away in fear?
That's what I was talking about.
He had to punch his point home. Yeah.
You've made your point. You punched him. He failed to punch you back, and he ran away. You are the victor. You have successfully persuaded everyone watching that milk drinkers are more manly. No need to chase him down and hit him with the knife. That's just overdoing it. The police probably wouldn't have even gotten called.
Yeah, but they did. And when they came, Florida man said he was defending himself when he was punching his cousin, and he denied using the knife during the fight. The deputies found the pocket knife in his pocket, and he was arrested on battery charged and booked into jail.
Did it have blood on it? That would make it even better.
The report does not say.
Yeah, okay. Well, hopefully Florida man and his cousin can get some couples counseling and learn to resolve their disagreements without puncture wounds.
Maybe uncle could be a better mediator.
Yeah, or at least step in, man. Get involved.
People should just use this to learn, remember, cool heads, because we get a lot of calls from people, and these things spiral out of control. You get worked up. You know, maybe you had 2 drinks. You know, maybe you just had a bad day or whatever, and they spiral out of control, and then you got a conviction, you got probation, and he's just like, this is not me. In that moment, that was them. But, you know, trying to keep a cool head, and what's really important was winning the milk dispute. You know what? Now he's going to have to hire some lawyer and all this over milk when he could have just said, almond milk sucks, man.
Right. And he could have said even worse things about almond milk than that, but we're going to hang on to our last shred of dignity here today. We've already had enough discussion about nut butter. But yeah, that's a strange hill to die on, and now we're digging a grave. It's a bummer.
Yep, and we're gonna end this episode in the grave because that's all the time we have for the day.
All right, thanks, Terry, and thank you, dear listener, for listening to Tales from the Brown Desk. Please remember, while we may discuss legal issues and provide information regarding the law to our listeners, we do not intend to create an attorney-client relationship with any listener. Our advice may not be applicable to some legal issues. Please consult with an attorney you've hired to review your legal situation before you attempt to apply the things we have said to your case. Tales from the Brown Desk is produced by Rigney Law and edited by Terry Ulm. If you want to ask a listener question, email Terry at TERI@RigneyLawIndy.com and entitle your email podcast question, and we'll read it on our next podcast. Unless we start getting too many questions, and then we'll just read the good ones. Give us new content for free, you suckers. Give us reasons to keep talking. Buzzsprout says we have 33 listeners now. That's 33 people out there who could be writing email questions. This thing is going to make us rich. 33 people. How much do you think each one of them are paying? When do we get our money? It's not going to make us rich?
No.
Oh, shit. Our newest faraway listener is in Norton Shores, Michigan. It's just north of Grand Haven on the Lake Michigan side. This is probably one of Kassi's friends. I know this because the listener is in Michigan and also because I have no friends. So it couldn't possibly be one of mine. The attorneys at Rigney Law do not comment on their current pending cases. Nothing we've said in this podcast is a comment on a case we are currently working on, even if your name is Chad, or if you just caught a virus that you said would go away on its own months ago. Bye, everyone.